From the main list, item number 1.
May it please your lordships. Lordships, in this matter, notice has been duly served, your lordship. However, acknowledgement card has not been received yet, your lordship.
Still,
Yes, your lordship.
please take down this application is further adjourned till 6 December to receive the service report.
Item number 2.
Oblige, your lordship. May it please your lordship.
Yes, is there any change in address?
My lord, in my humble submission is that in the last occasion, my lord, on the writ we have filed the writ number 54, my lord. The respondent number 2 has been served to the address which is mentioned there, my lord. The same address she received also. So, my lord, I may be kindly be allowed to ascertain the address from respondent number 1 since she is working with respondent number 1, my lord.
That direction was given to you on 14 November.
But my lord, to that aspect, my lord, I have not been properly instructed as to how to attain the address, my lord, because I suppose that even respondent number 1 is not even sure, my lord. So if she could ascertain, because she's working with respondent number 1, then
Because you have to give the proper address.
yes, my lord,
You
I will
give
show
the
you.
wrong address and it is not served, ex parte order is passed.
She was served, my lord, on the writ 54, my lord. She was served on the same particular address.
When?
My lord, writ 54 was when it was in before the single bench, my lord. The respondent number 2 was served in the same address. So, my lord, I pray that if
At more or less the same time.
yes, my lord.
This will be the official address.
Learned counsel for the appellant confirms that there is no change of address of the respondent number 2. Inasmuch as service of cost papers in the corrected appeal WA number 54 of 2024 was effected contemporaneously at the same address. Paragraph. In that view of the matter, advocate on record for the appellant is directed to effect fresh service of the notice by registered post with AD and through a private courier to the respondent number 2 and file an affidavit of service before the returnable date. We make this appeal returnable on 11th December 2024.
Highly obliged, my lord.
Item number 3.
May it please your lordships. We will continue, my lords. In fact, on the last occasion, my lord, I was submitting your lordships. Now, my lord, the grounds, my lord, urged by the state for withdrawal of the license, my lord, broadly speaking, my lord, are 4. Number 1, my lord, they have raised the question that the Commissioner of Transport is not the authorized person to sign the agreement or the renewal, and therefore, my lord, this is not an enforceable contract, even if it is presumed to be under Article 299. Now, my lord, in this respect, my lord, my humble submission, your lordships, is that when I filed the writ petition in 2021, my lord, seeking necessary direction from the court, my lord, to the state government to consider my renewal application, my lord, there an affidavit was filed, my lord. An affidavit was filed by the Secretary Transport and Commissioner of Transport. Now, these are the 2 authorities who were specifically mentioned, my lord, in the rules of 2009.
I made a notebook. Yes.
Yes, my lord. Now, my lord, my answer to their submission, my lord, of the state is by an authorized person is this. My lord, admittedly, my lord, the settlement, renewal, etc. is governed by, my lord, the rule of 2009, my lord, statutory rules, and the policy decision. Now, why the policy decision? This is just not my submission, your lordship. In 2021, when I filed a writ petition, my lord, for a direction to the state government to consider my renewal application, an affidavit was filed, my lord, and that affidavit was filed by number 1, my lord, the Secretary Transport and Commissioner of Transport. Now, my lords will take note of the fact that Secretary Transport and Commissioner of Transport are the only authorities, my lord, who are named in the statutory rules of 2009. Now, so far Commissioner of Transport is concerned, my lord, Rule 5 categorically say it all depends on his satisfaction. If he is satisfied, all the norms are fulfilled, then he will send the application to the Secretary of Transport. So obviously, my lord, the approval comes from the Secretary of Transport. Now, what kind of approval, my lord, in a prescribed form?
No, but not. You have also placed a more important document.
Lordship.
Page 144.
Lordship. That policy decision? Yes, my lord, policy decision, my lord. So now, my lord,
There it says,
lordship.
the Commissioner of Transport then signs the lease agreement.
Yes, my lord. I'm just coming to that. Yes, exactly, my lord. So in that affidavit, my lord, at paragraph 5, my lord, paragraph 5, they made a categorical, this is as good as an undertaking. The secretary, who is the approving authority, and the Commissioner of Transport, jointly they made a statement in paragraph 5 of the affidavit that come to us, we will do it favorably. The word used, my lord, favorably, you know what it means. And we have done it to others also. We have renewed in case of, they have cited the instance that these are the waivers we have renewed. Now, my lord, admittedly, your lordships, the settlement is governed by a policy decision and the rules, statutory rules. Now, as per the policy decision, my lord,
144.
Yes.
144, my lord, it is very clear and categorical. And in the paragraph 5, they said, my lord, we will consider it as per the rules and this policy decision. That is their submission which was accepted by the court. And while disposing of the writ petition, my lord, they took note of the statement made in paragraph 5. And while disposing, my lord, this court has also directed that the consideration would be done expeditiously within a period of, my lord, preferably within a period of a month. So there was some kind of direction also there as well. Now, my lord, based on the, my lord, their statement and the order passed by this honorable court, the process was initiated. Now, my lord, how the process was initiated, your lordships? Writ petition.
First petition.
23. Now, my lord, how the
116.
now how the process was initiated, my lord? I'll just take my lord to that.
Where is that document? As I said, we will consider favorably.
My lord, I'm coming. This affidavit. Affidavit.
Page 77.
Page 77, my lord. Relevant part is at page 78, my lord, paragraph 5.
This is the first writ.
My lord, this is the, my lord, of course, pertaining to these issues, my lord, this is the first writ, 23. This is, my lord, yes, first writ, 21. 21, my lord. Paragraph 5. May I read, my lord? Paragraph 5, my lord, page 78. May I read, my process was initiated by the Director, Commission.
Yes.
Yes, my lord. So, my lord, shall I read? My lord has gone. Yes. Now, that is very clear. One, favorable. Other thing, we will do as per statutory rules 2009 and policy decision. As I pointed out, statutory rules, who will sign, my lord, is totally silent. Only thing it say, my lord, it depends on the satisfaction of Commissioner of Transport. He plays a huge role. And my lord, approval, my lord, in what form it is not prescribed. Approval comes from the Secretary and Commissioner. But this is an affidavit, my lord, jointly sworn in by, my lord, filed by Commission Secretary of Transport and Commissioner, both the authorities under the statutory rules. Now, my lord, based on this, my lord, the writ petition was disposed of. Relevant part of the order is at page 83, my lord. Page 83, my lord, paragraph 2 onwards. If I can read it. Yes, my lord. So, my lord, this petition was disposed of, my lord, taking into consideration the statement made in paragraph 5. This is categorically mentioned in paragraph 2, my lord. And further, my lord, there was certain direction, my lord, in paragraph 4. The direction to be decided preferably within a period of 1 year, 1 month. Now, my lord, pursuant to this, my lord, action was initiated. Next page, page 84. The Commissioner of Transport. My lord has got it. That is, my lord, dated 30th May 2022.
Yes.
Yes, my lord. So, my lord, by this order, my lord, if your lordship look into the bottom, my lord, copy of it, this was sent to the Transport Department. In the bottom, number 1. And 2, 3, 4 are the licensee. So, this was sent to the Transport Department. And, my lords, in the last paragraph, they say, if I can read it, therefore, in order to comply with the direction, there is a direction, my lord. Now, what the state want to say, there was no such direction. There was a 2-part, my lord. 1 part, the statement made in paragraph 5 of the affidavit was taken into consideration in disposing of the matter. And number 2, my lord, court has given a direction to decide it expeditiously, preferably within 1 month. So there was a direction, my lord, and the authorities are under obligation to decide, my lord. So that is what is mentioned in last paragraph of this order. Now, my lord, thereafter, at page 87, my lord, I have filed the application, requisite fees, and although that was not required because that was already paid, my lord, during the existence of the first lease. But even then, since there was a direction, my lord, to file a fresh application, we have filed a fresh application. That requisite fees of 250 was paid through challan, my lord. These I have annexed in the next pages. And then ultimately the agreement was entered into, my lord, that starts from page 87. That is dated, my lord, 1st day of June 2022. Now, my lord, recitation in the agreement, my lord, first paragraph, it clearly say the governor of Meghalaya represented by Commissioner of Transports. So that's on behalf of the governor, your lordships. And my lord, and my lord's paragraph, page 89, your lordship, of this agreement. Now, clearly permission has, there is a reference of permission. Second subparagraph, page 89. If we can read that. And whereas the licensee is permitted to operate the weighbridge on terms and conditions contained in the agreement for a period of 3 years in the date of this agreement. Now, my lord, this is a renewal, your lordship. I just want to clarify one thing. Because even the learned single just made a distinction between the first settlement made in 2017, original settlement, my lord, original granting of the license, and this renewal license. He made a distinction, learned single judge, to the effect that in the first lease, my lord, in the first lease, it is categorically mentioned that government has permitted the lessee or the licensee to set up weighbridge. My lord, obviously, my lord, I need to clarify here, my lord. The first lease is for, my lord, lease, my lord, the tender was invited from interested parties, my lord, having land in the designated areas to set up and operate weighbridge. It's not that, my lord, tender was invited from the from the person having a weighbridge in their land. So this very purpose of the tender was to set up an weighbridge. So once the tender was settled, in the first agreement, it is mentioned, yes, by the agreement, it has been clearly mentioned that you are now permitted to set up your weighbridge. Now, that thing will not come here. Because this is only a renewal. So far, the weighbridge is concerned, my lord, it is already in existence. So I need not seek a permission to set up a weighbridge again, my lord, under this. Here, what I need, my lord, permission to operate for further period of 3 years. And that has been categorically mentioned at paragraph 2 at page 89.
No, this 2017 agreement
Lordship,
must have expired in 2020.
2020.
Then from 20, what you were doing?
My lord, that period, my lord, we have categorically, they have also, I'll take my lord also that. I'll try to clarify that. Because of, my lord, there was some ad hoc arrangement. Either there was total disruption or there were some ad hoc arrangements, and they also considered during that COVID periods. I'll take my lord to their evidence also.
No, we have already been taken. There was a temporary extension.
Temporary ad hoc arrangements, my lord. Either there were total disruption and
Show
for
those,
some.
show those documents.
260.
Where this
260. 260, my lord. This. $260. Page. My lord. If I can read my, this is the affidavit filed by the government, their statement, paragraph 4, 260. If I can read that paragraph, Your Worship, this is important.
Then what happened after 31st December?
Well, after 31st December, either there was total disruptions, there were most part because they have admitted because of the, my lord, the situation created by the COVID. So my lord, that there were ad hoc arrangements, there were abnormal situation, my lord, the COVID, they have admitted in this paragraph, your lord.
So there was no further extension.
No further extensions. The 3 months. Now, my lords, when my lord I was operating as such, in order, 10. Now I'll take my lord to page 108, for which my lord I had to file the writ petition in 23. After the license was renewed, my lord, I resumed the operations, and while I was operating this, my lord, to my shock, I received a letter dated 14 July 2023. That is at page 108, my lord. Now, my lord, as per this letter, number one, my lord, this is a unilateral decisions. No opportunity of hearing or shock cause has been issued, my lord. Now, these letters say, my lord, that extension is up to 39/23 as conveyed by government letter dated 26/23. Now, my lord, what is this 26/23? Because one of the stand taken by the state government, that I should have challenged also that 26/23, my lord. Now, 26/23, my lord, in course of the hearing, my lord, the learned single judge asked, what is this document? And ultimately, that document was placed before the court. Now, the 26/23, my lord, is an interdepartmental communication. Like this order, my lord, no reason cited why, my lord, the tenure of the license has been shortened. No reason has been cited. It's a unilateral decision. I have not given any opportunity. Similarly, my lord, in the interdepartmental communication, my internal communication dated 26/23, my lord, when placed before this court, my lord, I had the opportunity to go through it. No reason has been cited, my lord, and there was no occasion, my lord, no occasion for me to challenge you. That copy was never served on me, and no reason has been cited why they abruptly wanted to withdraw the license. Now, my lord, this letter, if I can take your lordship, that is at 296, that internal communication, my lord, 26/23, that is at page 296. Man. That is dated 20th June 2023. Now, this is from, my lord, Deputy Secretary to the Government of Meghalaya to the Commissioner of Transports. Not even a copy, my lord, forwarded to us. And my lord will note no reason cited. Why Why this abrupt withdrawal?
Where is the 4th July letter? You showed just now.
108, sir. 108. Impeach order.
108, my lord.
Sorry, it's 296.
296, my lord. I'm sorry, your lordship. 296.
22.
He's not on the chili. This is the, my lord, the internal communications. And so far the impugn order which I challenge, my lord, that is at page 108.
Yes.
So, my lord, here what I want to show, my lord, I have challenged the impugn order, my lord, dated 14 July 2023, by which the tenure has been shortened. And that was a number one for the reason unilateral decision without affording an opportunity of hearing, withdrawing a license, my lord, without affording any opportunity. That itself, my lord, vitiate everything. Now, the stand of the learned Advocate General, then I should have also challenged this internal communication dated 26/23, my lord. Now, my humble submission, as my lord has gone through it at 296, that was an internal communication, and that only substantiates the fact what I am saying, my lord. This is a unilateral decision taken, my lord, behind my back. With this copy, my lord, that internal communication was never served on me. Even the copy was not served. And secondly, your lordship, they have not cited any reason there. Now, my learned senior friend is saying there are so many reasons: unauthorized person, COVID situations. Then, my lord, there was no direction from the court. He could not produce any scrap of documents, your lordship, showing that these are the reason for which, my lord, this impugn decision has been taken. And, my lord, I submit with confidence, my lord. Even now, my lord, they do not have any records, my lord, that for this reason it has been withdrawn. Not a single communication has been placed before the court that, yes, this is the records, we have recorded, these are the reasons. These are all, my lord, concocted stories, nothing else.
No, we have to evaluate the rights acquired by you by these documents.
My
But what the learned Advocate General tries to impress upon
lordship.
is that this apparent state of anarchy
Lordship.
in 2023, it is being extended for a very limited period, whereas in 2022,
3 years.
it has already been extended for 3 years.
Lordship.
Therefore, the officer making the extension in 2023 is oblivious of the extension in 2022. Otherwise, he would have referred to it.
Lordship. There is no reference.
And whether it goes to suggest that the 2022 document was, even if the commissioner was authorized to sign documents, to sign the lease agreement, he signed that particular agreement without any authority.
My lordship, my humble submission, your lordship, here I will rely on two things. Statement made in that affidavit in 21, paragraph 5. Now that was a affidavit sworn by your lordships, Secretary of Transport,
Say, for example, the Registrar General is authorized to execute documents of the court,
lordship,
but taking prior approval of the Chief Justice.
lordship,
Then one particular document comes out where he has signed.
lordship.
And from circumstances, it appears that he has not taken any approval and done it himself.
But here your lordship,
That is what the
that is what the submission of my learned senior friend
appears to be now.
And that is in the mind of the court. My lord will see, my lord. I am an outsiderist.
But then whether by that some valuable right has been conferred upon you, we have to see.
Yes, your lordship. Now my question is, your lordship, my submission will be this, my lord. All this has been done after making submission before the courts, and so far authority is concerned, your lordship, whether the Commissioner of Transport has the authority, my lord, the policy decision is very clear and categorical, my lord. So there will be a requirement that each individual case, there has to be an authority, my lord. My lord, my humble submission is not required at all, because this policy decision exists, my lord, and it generally say it is the, so this is, and that was, my lord, will take note, my lord, that was a cabinet decision. That was a cabinet decision duly notified. So, my lord, authority comes from there. In individual case, a separate, distinct authorization, my humble submission, is not required at all. It's not required at all, and this is more so when they made a categorical statement, both the authorities, my lord, Secretary Transport and Commissioner of Transport, before the court by filing an affidavit, making a categorical statement that we will do it favorably.
There is no doubt he had the authority.
Lordship.
But the thing is, you know how the government works. He has to prepare a note sheet, a lay note, etc. That I prepared this agreement, so do I sign it for signature? Then the higher authority says that approved. Then he signs. Perhaps that is the system.
What is this? No, my lord, 19, if I can take your lordships, there was some further communication also. If I can take my lord to 293, page 293, there was a communication from the Secretary, Under Secretary of the Transport Department, 293, my lord. Well, 11th May 2022. Now, this is from the Undersecretary to the Government of Meghalaya Transport Department. Commissioner of Transport, Meghalaya. Now, it says, I am directed to forward with a copy of the letter number such and such, along with enclosure received from the Government Advocate in Meghalaya High Court, which is with a request to take necessary action as per the order of the authority. This has the approval of the competent authority. So, my lord, he has been asked, you go and do as per the requirements. So, my lord, here my humble submission, if you
All these were placed before it is flagged by us. It is.
okay. So, my lord, what I want to say, your lordships, individual, my lord, authorization in this case is not required. There is a policy of decision, there is a statutory rules, there is a policy decision. No policy decision has been placed before the court. An affidavit, they made a statement, my lord. So, there is no scope, my lord, that there should be an individual, my lord, authorization.
So since when your those personnel were withdrawn from your
Yes, my lord. Now I'll come to that. Yes, exactly, your lordship. Now what happened, whatever has been improved in the writ petition of 23, your lordships, there was a stay order. Now, my lord, when the stay order in force by a letter dated, my lord, 16 January 2024, impugn order was withdrawn. Now, with the withdrawal of the impugn order, my lord, these
The
episodes,
stay order continued till?
my lord, stay order was to continue, my lord, stay order was passed. Last stay order extension, my lord. I'm just giving you a lordship.
Stay by the trial court or appeal court?
Writ court, my lord, and it's not vacated with the impugned judgment and order only, sir. Date is, my lord, 28th May 2024.
252, your lordship. My lord, if I can take your lordship to 251, start at 251. And my lord, the extension order is at 254. So, my lord, by the extension order at 254, my lord, the interim order was extended up to 29 January 2024. That is immediately after, my lord, reopening of the court after winter vacations. In the meantime, what happened, your lordship, on 16 January, when this was holding the field, 16 January, at 255, my lord, the impugned decision under challenge was withdrawn. Next page, my lord, 255. At 255, my lord, that was withdrawn.
Yes.
Now, my lord, what is the consequences of this? My license was restored, so I was operating it. Now, on 1st February, my lord, 1st February 2024, what the government did, they had withdrawn the, my lord, enforcement official. Without enforcement official, we cannot operate. And relocated them, my lord, 2 kilometers away.
Yes.
And
That
in a
way,
very shallow
your first prayer is for closure of that.
Yes.
And alternative, together with deployment of
Agree.
staff in your
Lordship.
weighbridge.
Lordship.
And
I filed the second writ petition. I filed the second writ petition of 24. These were my two prayers. Close down the government weighbridge, because normally policy decision, my lord, the scope of review is very narrow. But here is the case, what they did, my lord, they were the stay order. They knew with the stay order, perhaps they could not touch me. So what they did, your lordships, they had withdrawn. So on the withdrawal of this, my lord, imperial order, what happened? The writ petition became infructuous. And that was my submission, my lord, when the matter we filed in 24 was taken up. And government has categorically considered, this is quite normal, my lord, and quite correct, categorically considered that yes, writ petition filed in 2023, my lord, in view of the withdrawal, has become infructuous. And when a writ petition has become infructuous, my lord, that leave no scope to the learned single judge, my lord, to make an inquiry how the settlement, because that issue do not survive before him. And this was not a public interest litigation, my lord. This is a writ petition filed by an individual, my lord, complaining infringement of his right.
you wish to file notes, Mr. Sen?
Lordship,
You wish to file written notes?
I have filed already.
You have filed already.
My lord, only short point, my lord.
He was on reply, Mr.
No, you
I
Sen.
have not, I have not done completed. I'll rely on some decision also.
What decision you will do?
Well, some few decisions, but he has also relied, well, just to counter some of, because he is one of the contention is that if an agreement on behalf of the governor is signed by an unauthorized person, this is not enforceable in law. Now, the other decisions say, my lord, if it is by an authorized person, policy decisions say commissioner or transport person, then under 299, it is to be presumed, Supreme Court, it is to be presumed, my lord, that everything is correct, sanction is there.
How many decisions you propose to cite?
Not, my lord. I have in fact a compilation with the index. So, my lord,
It
we
has
just come to the relevant paragraphs.
It has a number of decisions.
We have given a compilations, my lord, with the relevant paragraph. So, my lord, this was my prayer in the written. I'll give it. I'll give.
Deal with your judgment.
Now, my lords,
So, Mr. Advocate General has cited 4.
Yes, my lord. And then just now I've been handed over with the,
Technologies, Union of India was NK Private Limited,
yes, my lord.
Glock Asia Pacific, and
Yes.
Vikraj Jaipuria.
Yes, my lord.
my lord, I looked into it. Most of his decision, my lord, he is relying, my lord, on the to substantiate the issue that if it is by an unauthorized person, then of course, my lord, Supreme Court says that that is not enforceable. But if it is an authorized person, Supreme Court says it is to be presumed. There is sanction, everything all right.
But your compilation we have not got. This is the respondent. No. This is the Learned Advocate General's.
I have lost.
This one, natural. The state of Meghalaya. This is their compilation.
Kashmir.
One day, how many matters are there?
Hearing sanction. Huh? Sanction, 299.
Any special fees for any part of it? No pattern. We will take it up on Monday.
Lordship Monday.
Only on one aspect, my lord, policy decision has been cited before your lordship of the government. My lord, what has been read is the introduction part of the policy, not the policy, my lord. Only one page I have to show, only policy, my lord.
Please do it on Monday. We will give you an opportunity.
Lordship, only thing I will pray, my lord, I have not completed. My lord. Factual part, there are certain other parts, my lord.
You are on reply, Mr. Sen.
Lordship.
On reply, mainly it is law.
Mainly.
But some facts which were unanticipated and brought by the other side, submitted by the other side, that can become the subject matter of
My lord,
reply.
in this case, what happened?
But not re-argument.
No, Lordship, what happened if your Lordship recollect, my lord? I have never submitted. Somehow your Lordship wanted, my lord, my learned friend to start. That's how
you
it started.
submitted. All these
You, my lord, factual, but anything, suppose any.
maybe not, you had not completed your submissions, but you had submitted to some extent, to
To some
great
extent, my lord, to some extent.
So we will not stop you. You complete your submissions, but then we have to give the learned advocate.
Yes. My lord,
Also a chance.
yes. I'll just, my lord, finish. I won't take much time.
On facts also.
Yes,
On fact. Yes, my lord. I won't take much time, my lord, again. I'll just conclude it, my lord, next time. Then he can reply, your lordship.
All right.
Because right now I'm somehow in the middle.
Mr. Said learned advocate who continues his arguments, but does not conclude the same. List this appeal for further hearing as the first matter in the list on 2nd December
Oblige, my lord.
for further hearing.
Item number 4.
May it please you.
Yes,
Your Lordship, the Meghalaya Power Distribution Corporation is in appeal in IBC matter, my Lord, Insolvency and Bankruptcy Code, my Lord. The issue involves is the issue relating to waterfall mechanism, my Lord. This matter will take some time, my Lord. Because
has it been admitted?
it has been admitted, it was posted for hearing today and tomorrow, my Lord, but because of the other matter, it could not be taken up, my Lord. The dates have been fixed for hearing.
I'm appearing for the writ petitioner. I'm being led by Mr. Venkatrama.
We are encouraging physical appearance, Mr. Sastry. So you give 2 dates where you have to do physically.
Sure, Your Lordship. I was there in the trial court. I was there physically. I'll be there physically.
You give us any 2 dates of your choice.
In the week of December, Your Lordship.
Yes, or after our Christmas vacation.
After Christmas vacation, because it will take some time.
Then 3rd January.
Third
When the court
February.
reopens.
January is
The whole of January it's closed.
closed.
So any first week of vacation of your choice, I will make myself.
February.
Whatever is convenient to my learned friend, I'll be there.
Yes,
Since
Mr.
he is on
Advocate
appeal.
First week of February, Your Lordship may have it.
General. Check up it. Empty. This Thursday, Friday. This is the 24 calendar. You have a drop 2025 calendar. Sixth, 7th February.
Wait.
6th and yes, madam. 6th and February.
Yes. And I would request you to, Mr. Sastry, you take the phone number of the registered listing. And before your learned counsel departs from Delhi to confirm that the hearing is taking place on 6th and 7th, and then the learned counsel should come here. All right?
Sure. Grateful.
So that no inconvenience is caused.
Yes.
All right?
Grateful. Yes. Okay. Grateful much. I will do that.
And I will tell the register listing accordingly.
Yes.
I will advise
Okay.
register listing accordingly.
Thank you. Gratefully, Raj.
Yes. This, 2 appeals are there.
No, one appeal only. One appeal.
One.
This will take time, Mr. Advocate General.
It will take some time.
All right. This appeal is specially fixed on 6th and 7th February 2025, comma, to appear as
My
the,
leader is there, Your Lordship.
yes, to appear as the only appeal. To appear as the only matter in the list on those 2 days. So that it can be finished.
Yes, madam.
Grateful. writ.